Welcome to Exit Matters. This is our 10th presentation. I just counted, and that's kind of exciting. We started this monthly online series last September. My name is Jen Carlo. I'm the program manager at Patient Choices Vermont, and we will introduce some other folks in just a minute. We're delighted to have so many of you join us today. We are taping today's presentation, and we'll be sharing a screen, so audience faces are not generally shown, but if you're at all concerned about that, you're welcome to be off camera. We'd love to encourage everyone to share your name and where you're joining from in the chat so we kind of have a sense of who's with us today. And Exit Matters normally starts with a brief presentation that I do on Act 39 and medical aid in dying in Vermont, followed by our featured speakers. But we have several today, so we're going to introduce everyone up front and then just get into the presentation. We'll ask as you go, please put any questions that you have into the chat. We're watching the chat, and we will pull up the questions as we can. So I'm going to introduce our speakers, and Amy is going to spotlight them for us while we do that. So first off, Betsy Walkerman is PCV's President Emerita. She is a lawyer by training and has a long history as a consultant, building and launching companies. Most crucially for us, though, she has a long history building and launching PCV. She worked alongside her parents, Dick and Ginny Walters, who founded Patient Choices Vermont and spearheaded the campaign to legalize medical aid in dying in our state. She then went on to serve as PCV's president from 2015 to 2024, and she's still with us on the board, chairing our legislative and policy committee. So we thank Betsy for her many, many years of dedication and service to PCV and to this cause. And we look forward to hearing from her more a little bit later. Michael Sorotkin is a longtime Vermont attorney and public servant, known for leadership in economic development, housing policy, and consumer protection, and as it turns out, medical aid in dying. He served as a Vermont state senator for the Chittenden district from 2014 to 2023 and was the co-founder of the Sorotkin and Nekrasin public affairs firm. Michael was instrumental in the legislative campaign to adopt Act 39, and he's going to tell us a little bit about that later. He just joined our board again last year, and we're delighted to have him back. Diana Barnard, Dr. Diana Barnard, was a founding board member of Patient Choices Vermont, and for quite a long time, the only medical advocate in the early days of the campaign. She's worked across the country in educational and legislative efforts related to medical aid in dying, is often called upon to present, testify, debate. She's board certified in family medicine and hospice and palliative medicine, and was an associate professor of family medicine at the University of Vermont Medical Center. She's a passionate advocate for high quality, patient-centered care. And I always say that I can't listen to Diana for more than about 2 minutes without learning something. So I'm sure that you're going to enjoy this. And finally, make sure, Amy, to spotlight this last speaker. It's Amy Bruce. She is PCV's first executive director. She comes to us with a long background in palliative and hospice care and a deep personal commitment to those areas. She holds a Master of Public Policy, and she has been with PCV since the end of 2024, and we're delighted to have her speak here today. So thank you very much. I am going to go ahead and start the very beginning presentation. And as I said, Exit Matters always starts with a brief presentation on medical aid in dying. And I am going to do the presentation just a little bit more briefly than normal today, again, because we have so many wonderful speakers and so much wonderful information to share. So I'm going to ask that you either put your questions in the chat or hold on to them until the very end of the presentation, and then I will be very, very happy to stay on as long as necessary at the end to talk with anyone who needs more information and to answer any questions. So, medical aid in dying. I promise I don't read many slides, but I always read this one because there's different components and they're all very important. So, what is medical aid in dying? It allows qualified adults who are terminally ill and who are capable of making their own decisions the option to receive a prescription medication to be self-administered to bring about a peaceful death at the time of the patient's choosing. And all of those elements must be included. It can only be accessed by qualified adults through a very specific process. And Act 39 lays out very specific qualifications to access MAID in Vermont, and these are really similar to all those in other U.S. jurisdictions as well. You must be an adult, of course, 18 years or older, and you must have a terminal prognosis a terminal diagnosis and a prognosis of 6 months or less. You must have the mental capacity to make healthcare decisions, and that capacity has to be present throughout the process, right up until the moment of ingestion. You must make an informed and voluntary request, and you must be able to self-administer the medication. And all of those qualifications must be met in all cases. There's no exceptions, no waivers, no shortcuts. The law is very clear on this. The process to access medical aid in dying in Vermont is also very clear. You need to make 2 oral requests 15 days apart to a prescribing physician, and you also need to make a written request. It's a form. It's on the Vermont Department of Health website and also on the PCV website in our clinician's guide, and that form will need to be witnessed by 2 unrelated adults who are not on your care team, no one who would benefit from your death. And you also need to have a second physician confirm that you've met the qualifications and you've completed the process for MAID. After that, the prescription can be written. People ask a lot of questions about the day of ingestion, so we offer this information because we know it's something that people truly want to know about. And again, happy to answer any specific questions later in the presentation. On the day of ingestion, the patient will take 2 anti-nausea medications about 30 minutes or so before the medical aid in dying medication. And after confirming again that they want to ingest the medication, they need to be able to drink the MAID medication without assistance. It's a compounded powder, 5 different elements, and it's mixed with about 2 ounces of a clear liquid. The patient will fall asleep very quickly, generally within 5 to 10 minutes, and will not awaken. The time to death can be variable. About 80% of MAID patients will die within 2 hours after taking the medication, although that time can be longer. And the prescribing physician should be well aware of anything that may cause a longer time until death. Again, the patient will be unconscious and will not know, but the family and support team should be prepared if there are elements that might extend the amount of time until death. PCV always strongly recommends hospice enrollment for anybody who is seeking medical aid in dying, and really anyone else. And one of the benefits to being enrolled in hospice for MAID is that the death can then be pronounced by a hospice nurse if you are under their care. Medical aid in dying is voluntary. That's so incredibly crucial. It's a patient-driven process. You can stop the process or rescind a request at any time, literally right up until you take the medication. That is in your control. It's important to note as well that no healthcare providers or pharmacists are required to participate in medical aid in dying. It's entirely voluntary for our medical providers as well. And doctors who prescribe MAID must also make sure that their patients know about all of their end-of-life choices. MAID, hospice, palliative care, palliative sedation, voluntary stopping of eating and drinking, anything that might apply to their particular situation. We have resources available to help folks talk to their doctors if that's something that's a concern to you. And again, this is important enough that we put it on 2 consecutive slides. We strongly recommend hospice enrollment. So Again, I am so happy to answer any specific questions that anyone has on any of that. If you can put them in the chat or hold them until the end of the presentation, happy to stay on as long as necessary to answer everyone's questions. For now, though, I'm going to reintroduce Betsy Walkerman and Michael Sirotkin and let them continue on.
I'd like to add my welcome to everybody attending today. Great to have you here and to see people from so many different states and walks of life. So the short story is that Act 39 was adopted in 2013 when Vermont became the first state to adopt a medical aid in dying law through legislative action. It was the result of 11 years of relentless work by a core team and hundreds of very strong activists and thousands of supporters. But going back to the beginning, there was so much involved, and those of us who were involved in the campaign all along are, we actually get a little overwhelmed just going back, looking at all the stories and all the relentless work that it took to advocate for this law during that period. So I got involved in 2002, and this is a picture of, go back the picture, thank you. This is a picture of the co-founders of PCV, my two parents, Dick and Ginny Walters, in the upper left, and early advocates. And I'd just like to take a minute here. Actually, David Zuckerman, who I think is online here today as well. I'm glad to have you here, David. David had actually introduced what we then called a death with dignity law in the late 90s in Vermont. And so the proposal had been made before Patient Choices Vermont was formed. But the campaign really became active starting in 2002. The picture in the middle is, and actually the upper left and the lower right are pictures from New York Times articles. I was sorry that I couldn't find a picture that included Bob Ulrich, because I know you're online here, Bob, and Bob was part of the founding team. So the people involved here were my parents, the several of their associates, all three of whom were retired medical doctors. And when Dr. Barnard got involved, she actually for quite a long time, this is my recollection, was the only actual practicing medical doctor who publicly advocated for medical aid in dying. The others were retired physicians. So this is the team that carried the main part of the work forward, and what began as a small initiative mushroomed into a large statewide movement. I want to go back to this previous slide. I want to credit Bob Ulrich. This first bullet here, it was, my understanding was that it was Bob's idea to have information tables at, I don't know if it was all the town meetings, but many of them. And we had a postcard drive. And for a long time, when my mother handed over all the files to me, I had a big stack of those postcards from 2002 and 2003 of people who wanted to get involved. That's how we built our original list. So even by year one, there were 3,000 people who were part of this campaign. And that number just continued to grow rapidly. Every former governor who is still alive and a lieutenant governor came out in favor and made recorded TV advertisements. People told their stories, especially people who were well known in the community. And by the time 2007 rolled around, when the first official independent poll was taken, more than 81% of Vermonters expressed support. Yeah, so I would just like to say, just like to ask if anybody attending today was involved, feel free to put in the chat any comments you may have. I see from David emphasizing that support was across all three parties, and that was really crucial for the passage of Act 39, that this was not a partisan issue. There was strong recognition that everybody faces the same issues at the end of life, and that we all have an interest in being able to make our decisions about how that process goes, at least to the extent that that's possible. Yeah, so some of the things that people did during that time, I know it may seem a little bit analog in this digital world, but in Vermont, even still today, writing letters to the editor, to local papers, was a really strong advocacy strategy. And our supporters, many hundreds, if not more than 1,000 of them, did that repeatedly through the 11 years. People also called their legislators. They came to hearings. I mean, our hearings were packed actually with both advocates and opponents. People made donations. You know, when we first started this, my dad came in 2002 and sat down in my living room and said he wanted to get this done, but he had a very simplistic idea of what it might take to pass legislation like this. And he told me point blank, I'm not raising any money. And I said to him, well, then don't get started, because we're going to need money. And so people made donations. People from out of state made donations, even though the draft law didn't provide access to them at that time. We had amazing support from two national organizations, the Death with Dignity National Center and Compassion and Choices, and many other actions. And I just want to express gratitude to all of the people who took many, many steps over that period of time to build the momentum in the campaign. So 11 years later, as I said, we became the first state to pass the law by legislative action. In Oregon, it had passed by referendum. And it's a very different process. And as Michael might want to comment, it's much harder to pass it by legislation. Since we have bienniums in our legislative work here in Vermont, it was introduced 6 times over 11 years. There were dozens of bill sponsors, long lists that grew with every time it was introduced. I didn't count all the hearings, but I did count the ones in 2013. There were more than 36 hearings and committee meetings in 2013 alone. And so I'm sure that over 11 years, there were more than 100. And we had, as I said, very strong collaboration with national organizations. So this kind of gives you kind of the organizational outline, but it doesn't really give you a feel of what the personal impact was on the people who were really trying to explain what medical aid in dying is and is not, and to address the fears and concerns that many people expressed. So a key part of the team, one of the first things I did when my dad asked me to get involved, was to introduce him to a lobbyist I knew, who then introduced us to Michael. And our lobbyists played a critical role, and this was really about relationships. I just can't emphasize enough how much the relationships with each individual legislator, representative, and senator was so important, and that required an understanding of all kinds of things about them, their personal history with the end of life, whether they had any stories of their own situations or their parents or friends, whether they knew any of the people who were starting to advocate for medical aid in dying in Vermont, which many of them did. This was an issue that we were pleased to discover that people do change their minds about, and they might have very different imp opinions than whatever church they're affiliated with or whatever other interest group they might be part of. And those were the stories that we really needed to emphasize. I'd like to just go back to that slide, and I'm going to turn it over to Michael now to comment on some of the nitty gritty that we went through over that period of time. Michael?
Yes, thank you, Betsy. I have to say that was an excellent overview and presentation on your part. This has been 15 years or 13 years since I lobbied for the successful passage of death with dignity or end of life choices or compassionate choices, whatever the name is. I'm really glad. I wish we had discovered it sooner, but I think medical aid in dying is the perfect terminology to use, and it would have helped us a lot to get this through if we had that term back then. One of the key points that I took away from my 11 years of lobbying this is a classic case of where people need patience to get to the end of the final passage here. And as an indication of this, my first meeting with Dick Walters when he hired us, my firm at that point, he said to us, he had spoken to people in Oregon. He had spoken to the lead sponsor he had at that point, who was Senator Ginny Lyons, and he felt that there should be no problem in passing death with dignity legislation within 3 months of that meeting. And I immediately shook my head and said, boy, that is one of the more Pollyannish views I have ever seen. This was a highly controversial, taboo subject matter. You don't want to be talking about death publicly anywhere, at least at that point, and at least at a time when only one state in the country had passed a law, and that was by referendum. And one of my maxims in lobbying was always it's 10 or more times easier to kill a bill than it is to pass a bill. And it's also 10 times easier to pass something, at least back then when it was in its infancy stage, to pass a bill through a referendum than it would be through legislation. We have David Dean with us, who was one of our chief supporters, a very smart legislator who helped us as a parliamentarian, dividing questions and fighting amendments back then. Legislators, by definition, are not necessarily so aggressive that they want to stick their necks out there. So it's a lot easier to say yes to a polling or a referendum than to put your vote out there. And we found that out very quickly. Another important point that the first 10 years of our efforts, we had a governor who was non-supportive of this issue. So people would frequently say to us, well, why should I stick my neck out there and vote for this when it's likely that the governor is going to veto it anyhow and you're not going to get a law? So back then, we had just Oregon had passed by referendum. Several years later, Montana passed by referendum, and Montana, all of these northwestern states, they enacted the law not through a legislative process or a referendum, but by judicial fiat. They said that their constitution required something along the lines of death with dignity. As I said, it was a taboo topic. Nobody really was anxious to talk about the dying process publicly, and even our organization, which started out as, I believe, Death with Dignity Vermont, and changed its name to Patient Choices Vermont. There was internal debate as to what we should call it, and it had 4 or 5 different names. The bill had 4 or 5 different names by the very end. I think the end game, it was end of life choices. But now we do refer to it as medical aid in dying, which is great terminology. Can't emphasize enough the importance of finances, expertise, and contacts with the people from Oregon, Death with Dignity National, and Compassion and Choices national organizations helped us at every step of the way. And that's critical that for any other states going forward now, that they stay in touch with states that have gone through the process. It was also critical. We got many amendments. I guess most of them were coming from the opposition, but even from our friends wanted to amend the bill. And we said, you have to stick with the Oregon model because at least Oregon has a track record and can show that their safeguards that they put in the bill were working. And there were very few situations of where the opposition would use fear tactics of encouraging suicide, people encouraging people to take their own lives so they can inherit money, all of those things. We were able to turn back to Oregon and say, not if you keep the Oregon safeguards in, which Jen talked about initially. We also had a little problem, even though we had a lot of personal stories to tell, and we had a lot of heavy hitters, including governors and congressmen who supported our bill. We didn't really have a bill like this was coming along at the time social media was in its infancy. And I will readily admit that my firm, while we had a great track record passing affirmative legislation in other areas, we did not have a lot of technological experience with social media. And finally, I guess after the first defeat of this bill on a roll call vote in the House, we learned that we had to turn to social media to get really people inundating the State House with messages and the correct messages. So we hired somebody and we got that correction made. And one of the other things I've learned over the years, and it's not easy, is that you have to be able to try and take risks with this kind of legislation. And by risks, I mean we needed to have actual votes. We went several years where the leadership and even our supporters refused to provide a vote for us because they were afraid of losing. And you hear in political parlance, never Nancy Pelosi saying, never take a bill out to the floor unless you can win it. And we finally insisted that even though we thought we were going to lose, and we did lose narrowly the first time we put this bill out in the House, we insisted that our supporters put this out to a vote. And I think that built the momentum for going forward, for people feeling in some ways guilty that they supported the legislation but did not vote for it because it was too controversial for them. But taking that vote was important. Another lesson
Could I,
learned. I'm sorry.
I'm sorry. I'm just going to do a
Okay,
quick.
I'm just about wrapping up. One of
Got
our
it.
main opponents was the disability community, and we had a woman named Deborah Lisi Baker, who I loved, who was the champion of disability rights, and she stayed against us. But we were able to find a lot of other disability people to show that there was disability people who were not afraid of this bill and thought the safeguards we were were working and were protective enough. And finally, the last vote we took, which we won by, and David Zuckerman broke a lot of ties to keep this bill alive, but we finally got this bill through on a one vote margin by having to deal with the libertarian view of this view. They didn't even want the safeguards. They wanted this to be a process where it could go forward just like any other normal procedure between patient. It should be patient and doctor. And we had to put in a repeal mechanism that the safeguards would be repealed 2 years forward to get those libertarian votes, and knowing full well that if we can get it forward, the safeguards would be put in place 2 years later, and that's exactly what happened in 2015. But to get the bill passed in 2013, we had to have a repealer section in there that said no safeguards for death with dignity. And that was a risky move, but we got it through to get that last vote. And now the bill is law and the safeguards are working. And here we are.
Thank you, Michael. It's my unhappy job to be the timekeeper because there is so much wonderful information here, but we do want to keep moving forward. So thank you so much for that. And we will, as soon as we get through this material that we're sharing on screen, we will stop the share so that everybody can see our speakers again and we can respond to questions. So I'll turn it back to Betsy for just a moment.
Yeah, just a moment here. You can certainly look at this slide a little more if you download the presentation later, but I just want to put medical aid in dying in context. And I think this is where there was a convergence of trends. There were long-term trends, 30, 40-year trends of the advances of medical practice, expectations of longer life expectancy, patient right to information. There were a lot of trends that converged at the time that the final vote was taken. So I won't go into more detail than that right now.
Thank you, Betsy. Bye.
So this is the final signing slide. Those are my two parents right behind the governor. You can see the Speaker of the House to the governor's right. David Zuckerman's in the back there. Madeline Kunin and her husband, John Hennessy, on the left. Both have been very active with PCV. Yeah, it's great moment. Appreciation to Governor Peter Shumlin. And I just want to say in closing that ever since Act 39 was passed, the one message that both Patient Choices Vermont has received and many of the legislators and people who are involved have expressed gratitude. That's the main sentiment that is expressed, and which is exemplified by this quote from Katie Lesser, whose sister used medical aid in dying about a year or two after it was passed. And with that, I think I'll turn it over to Dr. Diana Barnard.
Thanks, everybody. You know, I hope I'm finding this interesting to be reminded of the process. And what I want to add to the fabulous information that's been shared so far is really a clinical perspective on what it was like for me as a physician and what was going on from the medical perspective, because we are talking about medical practice. You know, first, legislative action is not necessarily common for physicians. And when it is often done as part of an organized effort. For example, the Vermont Medical Society might garner support to get physicians to come and speak about the importance and safety of vaccines, for example. But it wasn't a common thing in my world. And this is the first time I ever actively worked on a piece of legislation. And it was a huge learning opportunity. You know, as folks have said, we had strong support from doctors who were either retired, and the doctors in that early picture, I just want to name them, Carmer Van Buren, David Babbitt, and Dick Austin, went a long way to talking to other doctors. But it was true that I was the only practicing doctor who was willing to speak out openly about what I saw really as one tool in a very large toolbox that would be very important to respect the deeply personal nature of dying. Physicians, even those that supported, were very reluctant to speak out, right? Writing a letter, contacting their legislator, certainly not going to Montpelier to testify. We had a huge coup. At one point, we made enough progress and had momentum that we were able to post a huge letter, I believe in the Burlington Free Press, that was signed by like 100 doctors. And that was a big deal to have some publicly sort of showing the support. Next slide, please. This is the kind of thing that we heard. A lot of what we heard is, look, this isn't necessary. And remember, again, first state to pass by a legislative process. When we started, it was only legal in Oregon. And then we had one other state come online, but it was still very new. We'd like to say it's not new now because we know how much of the population has access, but this was a different time, and for some people, the times aren't that different. So here's the things we heard. Oh, we have medications to treat pain, and people just need to advocate for pain. People said, we don't need to help people die. What we need is more hospice and palliative care. And of course, we said, everything is needed. We need all these things. We need more understanding of treatment of pain, and we need more hospice and palliative care. And even if we have those things, we still need this law. And in fact, along the way to passage of our Act 39, we helped support and pass other laws that clarify patients' right to know all of their end-of-life options and to have clear information about palliative care and hospice. And while some doctors probably still curse my name because of it, the first time we had mandatory CME for doctors renewing their license in the state that said you need to prove that you've taken a course about pain and about hospice and palliative medicine as a means of trying to assure that we were building the best treatment all along, even for people that might never want to use medical aid in dying. People also told us that it was really rarely needed, and that when it was needed, that doctors knew what to do. And this was sort of saying the wink and the nod, like don't worry. And this was, of course, very distressing to hear because a couple of things. Of course, it's not good to have something going on under the table because you have to be savvy to access it. There's no way to know if what's happening is really legal or if people are protected. And it actually also countered something that's really important, which is for people that have no interest in medical aid in dying, hospice and the use of medications like morphine can be used safely for people who are hoping to live a very long time. And it really fed into the fears around that taking too much morphine is all you need to hasten your death, which is absolutely not true. And then, of course, we heard a lot about this is not what physicians are trained to do. We're supposed to prolong life, and we should not be a part of what was seen as playing a role in what, of course, we recognize as hastening death. But of course, physicians have to learn new practices all the time. And, we've learned at times how important ventilators are or artificial nutrition. And then a few years later, we learn, oh, well, those aren't always good. It depends on the patient and their clinical situation and very personal values. Next slide, Jen. So here's what we tried to say in response and to help educate. And I can't emphasize enough how many times you have to say something to counter a fear. We said it again and again and to people again and again, and it was in the letters to the editor and discussions with legislators and in every testimony that I gave. Number one is really to help people understand that, first of all, our ability to manage pain is a little more complicated and isn't always as good as we would like. And there is so much more to suffering than physical pain. And this is really key, that understanding existential distress and other factors play a role when somebody's assessing the quality of their life and whether or not life is worth living, very individual. So what we're talking about is having access to options. I mean, I believe the official title, right, of the law is patient choice and control at the end of life. And it was just a very descriptive process to try to understand what we were looking for. I absolutely we supported the need for more information about and earlier referrals for hospice and palliative care and more resources into increasing access and also helping people understand that even with the very best of hospice and palliative medicine, that people will suffer and that not all suffering can be easily attended to. And for some people, it reaches a point again where the quality of life is so compromised, suffering is so great that a death which is coming anyway is welcome to come sooner. And as so many people wish for, be quick and be peaceful. Um, I mentioned before this concept of like, what is it that we're supposed to do in medicine? And I'm using the word physician to speak directly to physicians being the prescribers right now in our state for medical aid in dying. But of course, we're talking about very important role for everybody on an interdisciplinary care team. But what is do no harm has changed over time. It doesn't mean always doing something or never doing something. You have to really put it in context. And I've already talked about the morphine issue. Go ahead, Jen. Um, uh, I want to, as Michael and Betsy both alluded to, just come back to this fact that Oregon was all we had. They were the only state that had a law, and they had data collection which showed that it was working well. And so we made a political decision to say we must pattern our law directly after Oregon because it was all that we could refer to say that it was working well. And so that's why our law includes what it includes in terms of a waiting period and a second opinion and the need for a written request. It was very deliberately done because of the need to show that what we had in Oregon had been working well, and we wanted to just duplicate that with Vermont language. And as I implied before, but it can't be said enough times, how many times we had to repeat simple concepts and beliefs that we held and we believed were reflected in the data, and to counter fears which were exaggerated and repeated. And often after a very thoughtful discussion with a legislator and you thought, oh, I think they kind of understand it, they would say, oh yeah, but what if Susie tries to off grandma early for her estate? And I cannot say enough about number one, respecting that this process is voluntary, most importantly for patients, and also for physicians, that people have not shown that they will pursue this when they don't want to, or that they can be coerced by family, or lack of resources, or things that people feel aren't important. This is very much a process driven by the patient and requiring the patient to be terminally ill and have capacity to understand their options all the way through. But the exaggerated fears repeated again and again. And as we all know, unfortunately, fear is a stronger motivator sometimes than solid evidence and education. So just to address the issue of anytime we're talking about this process, we're really trying to make sure we have safeguards. And again, we believe the safeguards with the time to contemplate, a second opinion, the waiting period were all very important. But I also want to acknowledge that the safeguards also can be barriers. And so you're really trying to have a balance. And so when people thought about things like, should we have a mandatory psychological evaluation or some of the other things, our judgment was that those kind of things were adding unnecessary barriers and that the safeguards from the practice we had were enough. And of course, now we're many years down the road and we have more states online, and we see that the core eligibility and safeguards are the same in every state, but in recognition of the safeguard becoming a little bit of a barrier, for example, like who can prescribe and the waiting period, some other states have taken the opportunity to change those based on the experience that has been provided by our efforts here in Vermont and other states. And I will say that I do believe there is still a lot of limited understanding in patients and families and physicians and legislators and all of us sometimes about what is real life suffering? What does it really look like? It's so easy to say if you have pain, you ask for morphine, but it's so much more complex, and it takes time to understand. And as I said before, as much as I promote hospice, everybody deserves hospice. It's the gold standard and an essential part of end of life care. And also, like any other thing in life, has some real limits that we have to acknowledge for those who suffer. Just to kind of sum it up again, from my perspective, from a medical perspective on the legislative process, oh my God, is it really like making sausage? You really don't want to see what happens because it felt dreadfully slow. It was very much showing up in person, as Michael said, be patient and deliberative and had a strategy. Um, we really repeating the same thing, just like when you learn CPR. You know, people sometimes have to hear things again and again and again to feel confident about it, and that was very true of the legislators. We did a lot of presentations, we did debates, I went to hearings, and it's not lost on me that even very powerful, well-respected physicians like Dr. Ira Byock, who was at Dartmouth at the time, who was really seen with such high regard when it comes to palliative care and end-of-life care, happen to also be very opposed and remain so to the concept. And I sometimes chuckle when I say to people, oh yeah, Ira and I had a few debates, publicly, with respect. I appreciate that some physicians feel differently, but I did not think it was okay that a personal feeling about it should get in the way of other patients who believe in it and doctors who believe in it being able to have this as an option. I think that's enough. So the law is working as intended. We haven't seen any of these fears come to pass. This law does not address all end-of-life suffering. And so we still need more tools in our toolbox. So that's a very complicated and important subject. And also to remind people that over time, while we negotiated and had to work hard for passage, the amendments that have been passed have received overwhelming support. And that includes, we at one point had another 48-hour waiting period after the 15 days. We added additional protections for all members of the medical team. We clarified that telemedicine is allowed for certain steps in the law. And the most recent one, which is allowing non-residents to access our law, because medical care should not be limited by the state you live in. And just a reminder that for those coming to our state from somewhere else, that all of the processes for the law must happen in Vermont in order to be protected by the law, which is a Vermont law, which does not apply in any other state. We are having more discussions about death and dying. That's great. There's more and more states are now passing laws, which are great. I have continued to advocate and actually testify in other states about the Vermont experience, which has been very powerful in Illinois and in Delaware, which came online this year. And there is ongoing need for support and education and need for doctors who are willing to consider prescribing under this law. So we have a lot of interest in people who want to come here from out of state, and that is one of our ongoing challenges. So things continue to move forward and evolve, and protecting the law, particularly in a political environment which is not supportive, is critical and important. And I hope what you heard earlier reminds you about the careful deliberateness of how we got to where we are and how we would go forward with any future changes. Thanks.
Thank you, Diana. Amy's going to condense the end part of her presentation. We did this strategically so that if we were running short on time, Amy could talk a bit quicker. Do you want me to stop share, Amy, or okay?
Sure. Yeah.
Then we can all see each other.
Yeah. So incredible legacy. it's when I hear it like that, again, I'm so honored to be moving the organization forward with Jen's support and our wonderful volunteers and our board. And as PCV was central to the passage of the law, PCV remains central to safeguarding the law and educating people about the law to this day and forward. When we're out speaking to the public, when we're getting inquiries through our website and over our phone line about medical aid in dying, we still encounter people all the time who aren't aware that they have this right in Vermont. And because really, as Michael alluded to, we don't like to talk about death and dying. And while our culture has moved a lot, I think in a healthy direction of being more open to talking about that, it still can be taboo. It's scary. And so people don't think about it until it hits home, either for themselves or a loved one. And then they think, oh, well, what are my options? And somebody may say, did you know we have this law? And they say, no, I don't know anything about it. And they call us. We don't receive any state funding to educate, do all this education work. We rely on donations from individuals and a couple of small grants, but we really are the central organization. The Department of Health refers people to us. The Vermont Ethics Network that handles supporting advanced care planning in Vermont refers people to us. So we really are a central location for people to get really comprehensive information about the law and how they may qualify, what other options there are. And we provide that not just to the general public, but again, to clinicians, to physicians who may, for the first time, be encountering a patient that expresses this desire and they realize, I need to learn about this. So one of the things on our website that's really heavily used is our clinician's guide. And we have medical advisors like Dr. Barnard and others who support physicians one-on-one to be able to help them feel confident to meet their patients' needs. So along with the education, we continue to stay informed on what's happening across the country. Diana talked about changes to medical aid in dying laws that other states have passed. And so we look to our community to ask, how is it working for you? To providers, how is the process for your patients? Are there changes and improvements that we should be advocating for? And continuing to update the legislature, the Department of Health, our legislators turn over. And so there are many people that were not part of the legislature when this law was passed or even the amendments passed. And so we stay engaged with them to let them know this is something that's on the books in Vermont that they need to be aware of. And also to really establish those relationships. So if there are improvements that we want to advocate for, we can go in and start doing that work. So ways to get involved, obviously you're here, so you're getting our communications and encouraging people to sign up for our mailing list so they can stay informed of what's going on in Vermont and across the country. There is increasing national opposition. There's some strong opposition groups to medical aid in dying that are a little more active right now, filing various lawsuits because they know they have support at the federal level to diminish this right. So as we've learned with other rights, nothing is permanent. We have to stay vigilant. And that's another big part of the work we do that your support funds. So, I really am just encourage you to keep having those brave conversations with the people in your lives. And we're here for you and for all of them if they need us. So thank you so much. We'd love to hear some questions.
Yes, two quick things. First off, there was conversation earlier about the hesitancy of doctors to come up front and be out front about the issue. And I just want to make sure that everybody understands that George Till, MD, member of the Vermont House, was the lead sponsor on the House version of the bill. He was an emergency room doctor and practiced, I don't know when he practiced, given the amount of time he put into the legislature. Secondly, I have since recently discovered that my doctor serves in a federally qualified health center and may not, under the rules of the center, advise on end-of-life choices. And that is, of course, a federal program. They can do it, but they're going to lose their job. And I think that's worth some attention to down the road. Maybe not with this administration, but there's always hope. Thank you.
I wanted to just clarify David's comment to make sure that people are aware. Federally qualified health centers do a wonderful job of caring for people in our state, and their numbers have increased, and the number of people in Vermont who go to them has increased. And Bernie Sanders has been a huge supporter. It's largely a very, very positive thing. They don't turn people away. However, because they are federally funded, they feel that their hands are tied because of the federal law that said no federal dollars can be used for this practice. So as it stands right now, providers who work in those centers, even if they support their patient having access, will not be able to prescribe. So it's an ongoing challenge, and one of those things in terms of access that organizations like Patient Choices Vermont are working on. How can we look at providers across the state, those who might want their patients to have access but can't for whatever reason or choose not to actively participate, to be sure that we are referring internally to get people what they need and when they need. And yes, David, maybe one day things will change. You said it very well. If anybody has questions about how to navigate that, who's going to a federally qualified health center, that's something we could follow up on.
Okay. I will call people's attention to some information that I put in the chat. I put in the address for the PCV website. Strongly recommend that you have a look if you haven't already. There's a lot of wonderful resources on there. Patient Choices Vermont is a privately funded organization, as Amy said. So if you enjoyed this presentation, would like to support our educational and other efforts, there is a link in the chat for that. All of you who registered will get a video or an email with a link to the video of this presentation, and it will also be available on the videos page of our website, along with all of our previous exit matters. I put Amy's email address and my email address in the chat, and you are more than welcome to reach out to us at any time with questions, comments, suggestions for future programs, anything you'd like. And I just want to put in a plug. The July Exit Matters will feature the Executive Director of End of Life Choices New York, Mandy Zucker. I think people are aware that New York has legalized medical aid in dying, and their target date for implementation is early August. So we want to kind of highlight the similarities and differences between the New York and Vermont laws. New York does have a residency requirement, but since we're neighbor states, we wanted to keep everyone informed on the progress of that process over there. There is a question, Diana, in the chat. Can physicians oh, you answered it. Okay. The question was whether physicians in FCHC can discuss options, and Diana's answer is there's variable understanding of what they can and can't do, but Vermont law mandates patients are informed of all options. So the answer should be yes. And there was a question on the day of ingestion about who's present when someone ingests the medication, whether it's medical personnel or someone else. And the answer is that it varies. It varies greatly from individual to individual. There are some prescribing physicians who choose to be present when someone ingests. That's by no means all. Some physicians are not present. If you're enrolled in hospice, sometimes hospice personnel will be present. And again, this is something that you need to talk about with your providers, with hospice, with anyone else who's involved in your process. Some people choose to have doulas or wayfinders with them. Some people choose to be surrounded by friends and family when they ingest. So it's really very variable, and there's no specific requirement under the law of anyone who must be present. All right. Any other questions? And so many thanks to all of our wonderful presenters. I cannot quite believe that we're ending right at 1 o'clock. I'm not going to lie. I did not anticipate that. But I will remind people that, some of us are more than happy to stay on. Sometimes there's a question that you don't necessarily want to ask in front of everyone. So if you don't feel that you got the information that you needed, happy to stay on a little bit longer. But thank you so much for joining us. And Betsy, Michael, Diana, Amy, thank you so much for your wonderful presentation.